Welcome back, Minister of Justice, the Honorable Delroy Chuck, speaking to us about plea bargaining. It's a critical piece of legislation, and it has an impact, will have an impact on the struggle to contain crime. So, Minister, you were going through.
And I was saying that we need to get at least 50% of the cases. Can you imagine, Ian, if the 700 cases, which, by the way, when September comes, it could be 800.
Yes.
Because additional cases are coming up. In other words, the increase or the incoming cases far outweigh those which are disposed of.
Absolutely.
Now, the point is that if we can get half of them, can you imagine, let's say 700, and we can get 350 cases where you have a plea bargain, 50%.
Yes.
Can you imagine the impact it would have, how much time would be saved, how much resources from the judge, the prosecutor, the attorneys, and the police would be saved? And I'm saying it is possible, but there has to be give and take. Not only on the prosecution side, but also on the accused side. So accused persons at the moment feel that their lawyers must go out there and fight the case.
That's right.
They have to take the advice of the attorneys. If the case is strong, even if it is weak, the chance of a jury convicting you or a judge sitting alone convicting you based on the facts is still very great. And once you're convicted in a trial, you might get a very high sentence. And in fact, you know, Ian, just this week, I know of a case where the attorneys urge the accused man to plead guilty. And in fact, the Crown would have dropped the case from murder to manslaughter based on the facts. He said no, he wants to try it. These attorneys were the third set of attorneys because the attorney was saying you really don't have much chance.
Yes.
So plead guilty to manslaughter, you might get 10 or 12 years, perhaps less. The case was tried. He was convicted for murder, and only a couple of days ago, he was sentenced to life imprisonment with a minimum of 40 years before he's considered for parole. Accused persons will have to bear in mind, you go for all or nothing, and you might end up in jail for a long time when even with the most serious offenses, if you can get a 15 or 20 years sentence with a guilty plea, I'm going to hold it out that once you've pleaded guilty, further consideration should be given by the state. And when I say this, Ian, what I would like to put in place, that the Parole Act for persons who have pleaded guilty, who have shown remorse, contrite, they have accepted that they did wrong, that they should be given, not entitled, but they should be eligible for early parole. In other words, if they go to the prisons and they participate in rehabilitation programs, their families keep in touch with them and they're in good grace with everything, then they should be allowed to serve a greater part of their sentence in the community, especially if the victims forgive them, especially if they admit to their wrongdoing and the family or the victim themselves said, yes, we're willing to forgive, and therefore the restorative justice part of the whole program.
Are victims a part of the plea bargaining process?
They will be, because in the negotiations, the views of the victims, where available, should be taken into consideration. Also, if the victim is no longer there because the victim is a murder case, then the families and friends of the victims will be consulted so that their views can also be taken into consideration. Not that these views are overwhelming, but at least the sensitivities and the passion and the feelings must also be borne in mind. But the point really I'm making now is that even if you get a sentence on pleading guilty, the state, and I intend to look at the Parole Act and also at the expungement law, so that those persons who having pleaded guilty maybe get early parole, and have put crime behind them and show that they are now living fairly decent, upright lives, maybe after 10, 15 years, they could be eligible for expungement of their sentence. So you see, we have to put these incentives and attraction in the system, Ian, because we need to get more guilty pleas. That has not been softened crime.
I was about to mention.
That has not been softened crime.
Yes, whether an unintended consequence could be that people feel that they would get off and they would not get as severe a punishment.
Because one of the things which I hope, Ian, is that those persons who plead guilty will see it as incumbent on them to try to not only lead a straight life, but to emphasize, especially when they get back in the community, that I want to put crime behind me because I want to be able to finish my parole without having to go back to prison. And also, if I really finish my parole and people can see that I'm leading an upright life, maybe I can get an expungement. Because I can tell you, lots of persons know, beg for expungement, but they're not eligible. They're not eligible. And believe me, it's sometimes cases come to me where persons who have been convicted have served their time 20, 30 years ago, and because they're not eligible for expungement, they don't get it, and I have to look carefully at whether or not to grant it. But what I would say is that in the regime that I'm putting forward, a person who pleads guilty, that he will be not entitled, but will be eligible.
Yes.
Especially after 15, 20 years, you can see that this man is not only a well-recognized, decent citizen in his community. There are persons who are deacons and pastors in church who have put crime behind them, and they still can't travel because they have a case that they committed 20, 30 years ago. And I'm saying that for persons who commit crimes, and they go and from the beginning show that they are remorseful, that they accept that they did wrong, and then thereafter can put it behind them, we must do something. Now, the bill itself, is really one that I hope that defense counsel, prosecutions will buy into. Because, firstly, the cases that are ready are those which I'm hoping that can be negotiated immediately. I would like to see plea bargaining be a major component of the criminal justice system. In other words, prosecutors must see negotiations with defense attorneys as a very important component to get rid of the vast majority of cases. At the moment, you have case management. And in that case management, the defense counsel for the accused can look at the facts. And if the case is overwhelming, it is almost incumbent on the defense attorney to persuade the accused it is in your best interest to plead guilty. At the same time, the Crown must bear in mind the nature and quality of the case. If the case is going nowhere, for heaven's sake, just go forward and say, and ask the jury to acquit because the case is going nowhere. And I would think, Ian, during this 2017, hopefully no later than 2018, there will be no case in the courts over 3 years. You have far too many over 5 years now.
Absolutely.
And I'm saying the plea bargaining, the question of the prosecutors, not offering any evidence, or for that matter, the judges who see cases coming year after year after year,
they themselves
may well have to put their foot down and say, this case has been before us for 5, 6, 7 years. The constitutional rights of the accused has been breached. If it is the fault of the Crown, then the case should be dismissed.
Mister, you're onto a very good case, and I think that if everyone buys into your vision and your advocacy, I think the country as a whole will benefit. It was great to have had you today on Issues and Answers. Minister of Justice, the Honorable Delroy Chuck. Next week I'll be back. Until then, Ian Bourne wishing you a pleasant day.